Hi, my name is Joanne Bartlett and I'm a business advisor with the Social Business Wales New Start team. We're here to help you through the early stages of social business development, including visioning, structure, incorporation, director training, governance and engagement, funding strategy, compliance and risk, and opening a bank account. Social Business Wales New Start is funded by the European Regional Development Fund and Welsh Government, and it's delivered by the Wales Co-operative Centre as part of the Business Wales service. The Wales Co-operative Centre vision is for Wales to be an international leader for cooperative thinking and action. Our mission is to develop a sustainable businesses across Wales and a strong and inclusive community by working cooperatively. We aim to be an important engine for Wales's economic growth by providing a comprehensive range of services to cooperatives, social enterprises, mutuals, and employee-owned businesses. We will develop and implement cooperative solutions to strengthen communities and promote inclusion. Welcome. Today we're going to talk about legal structures and help you to work through the various models and gain a better understanding, and also help you to make the right decision for your business. For the remainder of this video, I'm just going to talk you through the slides. So before we look at suitable structures, I want to clarify a few things that sometimes confuse people. Legal structure encompasses the legal form that you use to set up the organisation and your governing document. This means the way that you govern the organisation. This session will help you to understand the importance of exploring the range of legal structures and help you to decide which structure fits best. Social enterprises are businesses that are changing the world for the better. Like traditional businesses, they aim to make a profit, but it's what they do with their profit that sets them apart, reinvesting or donating them to creative, positive social change. Social enterprises are in our communities and our high streets. They range from coffee shops and cinemas to pubs and leisure centres, banks and bus companies. By selling goods and services in the open market, social enterprises create employment and reinvest their profits back into the business or the local community. This allows them to tackle social problems, improve people's life chances, provide training and employment for those furthest from the market, and support communities and help the environment. So, if someone says to me that they want to set up a social enterprise, I emphasize that the enterprise will not belong to them. They will not be able to keep the profits themselves if it becomes successful, and they will not be able to pass it on to family members or sell it down the line. Unfortunately, the profit isn't yours. Here's some examples of social enterprises. These examples define the field of activity, the type of organisation that you are, and they shouldn't be confused with the legal structure. So there's some great examples of worker cooperatives, housing associations, trade-in charities, credit unions, development trusts, and community land trusts. Like I said earlier, there's also things like coffee shops and banks, and lots of other examples of social enterprises. So here's a list of types of legal structures. These legal forms cover over 99% of the legal forms used by social enterprises under English and Welsh law. Some of these legal forms are much more commonly used than others. The aim in covering all these structures today is to be comprehensive about the options available. What do you want from your legal structure? Viability of business? What startup capital is needed? Who will be the members? Do you want your members to participate economically in the organisation? And do you want to apply for public sector grants? These are the types of things you will need to think about when making your decision about your legal structure. It would be helpful to discuss these things with all the founder members. Before we go any further, we need to make sure that we understand the concept of incorporation, what it means to be unincorporated, and what it means to be incorporated. So unincorporated organisations do not have a separate legal identity from its members. Here's some examples of unincorporated organisations: voluntary groups, community associations, scout groups, tenant and resident associations, and charities. When an organisation is unincorporated, the law does not recognise any difference between the organisation and its members. The members are personally liable for all the debts of the organisation. If a member signs a contract on behalf of the organisation, he or she can be held personally liable for that contract, even after leaving the organisation. There are real cases where this has happened. This legal form should only be used for very small enterprises where there is very low level of risk. The governing document for an unincorporated organisation is known as a constitution, and it is governed by the Management Committee. So if you are unincorporated, there would be certain triggers that indicate it's time for you to incorporate. And this is usually when the risks increase. If you are an incorporated organisation, the organisation is legally separate from its members or shareholders. You would register with an appropriate registry. The organisation can enter into contracts in its own name, and members' liability is limited to the value of any shares they hold or guarantees that they are given. Usually, they are limited by guarantee of £1. However, directors can lose their limited liability in a few specific situations. For example, wrongful or fraudulent trading. So just be careful with that one. For the remainder of this session, we will be looking at incorporated structures, as most social enterprises do incorporate. The first three types of incorporated legal structures we will look at are companies: company limited by guarantee, company limited by shares, community interest company. A company limited by shares mostly entails private equity and therefore is difficult to reconcile with social enterprise principles, except in a community interest company situation. Not-for-profit means do not distribute their profits to their directors or members. A CLG can have an asset lock included in its articles, but this asset lock is not entrenched. However, the Wales Co-operative Centre have models that do include a dissolution clause. So you'd be welcome to use those if you worked with us to develop your business and its articles. Registered with Companies House, although Companies House has absolutely no role in the regulation of the social purpose of a company, if an ordinary company with a social purpose seeks to amend or remove this purpose, Companies House will have no concerns about this. You can be registered as a charitable company. To do this, the articles must have strict guidelines that apply to how any profits are distributed. Another plus for a company limited by guarantee is obviously the limited liability for the directors, which is usually £1. Company limited by guarantee, here's some of the minuses. It is only their great flexibility that enables the principles of social enterprise to be written into company rules. Companies House have absolutely no role in the regulation of the social purpose of a company. If an ordinary company with a social purpose seeks to amend or remove this purpose, Companies House have no concerns about this. Company shares as they normally operate are particularly unsuited to social enterprises. A share is a share in the value of the company, so there's no social wealth created. Company shares are normally one share, one vote, not one member, one vote. It is very difficult for a company to buy back its own shares, so it's hard to prevent shares ending up in the hands of non-members. Shares in a private limited company cannot be offered for sale to the public. Community Interest Company, or KIC. This is a new company form which only became available in July 2005. However, it is increasingly being used in the social enterprise sector. The community interest statement must pass the reasonable person test. The regulator must be satisfied that a reasonable person would view the company as being for the benefit of the community. The assets of the company are locked in for the the assets of the company are locked in for the community benefit. Whilst this does not preclude the paying of wages to directors or limited distribution of profits, most of the wealth of the KIC must be locked in for the community benefit. So the pluses. The pluses are there are no restrictions on the trading activities KICs can undertake as long as the purpose is clearly for the community benefit. So we're always focusing on the community benefit in a KIC. The regulator has proved liberal in assessing social purposes. So the KIC regulator will regularly check you are meeting your social purposes. And annually you would submit a report to the KIC regulator to tell them about your social purposes and how they've been met. Whilst shares in KICs are closer to social enterprise principles, they are still normally based on one share, one vote, and are difficult for the company to buy back. However, the par value of KIC shares means that the bulk of the wealth created is held for community benefit. The dividend cap is currently 10% of the paid up share value and no more than 35% of distributable profits. There are well over 3,000 KICs registered, 76 in Wales, only 16 were limited by shares. So that means the remainder were limited by guarantee. The minuses are, it's still early days for KICs. People are learning more and more about them and they are becoming more popular. And as I said earlier, once a year, a KIC has to submit a report to the regulator on its activities. This is called a KIC 34 form, and you will tell them all about how you've met your social objectives. But I think that's a good thing. Charitable status. So this means that a potential charity must have goals which are charitable, have rules which are charitable, and the things that it does must be charitable. The Charities Act lists 13 descriptions of purpose. You can find these on the government.uk website. The descriptions of purposes is a list of broad headings that a purpose must fall under to be a charitable purpose, and this is a legal requirement. Each description serves as a general heading under which a range of different charitable purposes fall. As I mentioned, companies limited by guarantee can apply for charity status if appropriate, but KICs cannot. Some social enterprises may choose charitable status in order to access grant funding. So here's some of the pluses. The tax advantages are not as extensive as people sometimes assume. Charities do have to pay some taxes. National non-domestic rate relief is mandatory at 80% on any property used wholly or partly for charitable purposes. The remaining 20% is at the discretion of the local authority. The number of VAT reliefs for charities is small. The misconception that charities do not pay VAT arises because many charities receive all their income from grants and donations. These are exempt from VAT, and so such charities have no VATable income. If a charitable social enterprise is well enough organised and the income it gets from sales can be set up in this way, it can claim back gift aid on sales. Customers who are taxpayers can fill in a form to enable the charity to claim back the tax these customers have already paid on the amount they pay for the charity's services. You may have done this if you've bought things from a charity shop. Many funders, especially from the public sector, do not require charity status. And of course, social enterprises should be making much of their income from sales. The minuses. Charities are heavily regulated. Excuse me. The basic relationship in a charity is that the donors give money to the charity with the intention of it ending up directly or indirectly in the hands of the beneficiary. The charity is therefore an intermediary, holding other people's money. Mainly for this reason, it is heavily regulated. The starting point for charities is that they do not trade. This is the basis of many of their tax exemptions. Clearly, this is a problem for social enterprises, the basis of which is that they do trade. They have to rely on a number of exemptions. Some activities are just not charitable in law. Imagine a village. If you wanted to set up a village hall in that village or an after-school scheme, then you would easily get charitable status. However, if you wanted to save the only village shop or set up a community laundrette, you could not get charitable status. Employees can only serve on the board on a case-by-case basis. There has to be explicit permission in the charity rules to allow situational conflicts of interest, and the lack of equity and the severe restrictions on loan finance to protect beneficiaries against speculation force charities to rely on grant finance. Charities and trading. Here's some examples. An out-of-school club or a theatre charging an entrance fee for a village hall, hiring out its rooms. A project employing people with learning difficulties, selling the goods they make, or a museum running an on-site shop, or a community centre providing a cafe. Fundraising events, raffles, lotteries, or small-scale trading, like selling calendars or Christmas cards. Oxfam shops are wholly owned subsidiary of the Oxfam charity. As the subsidiary, my tongue around that, blah, 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 is an incorporated body in its own right. It is legally separate from the charity, but the charity must not subsidise a subsidiary. So be careful. CIO, Charitable Incorporated Organisation. Whilst the CIO is less regulated than the previous charitable company, limited by guarantee, the CIO was created in response to requests from charities for a new structure which could provide some of the benefits of being a company, but without some of the burdens. It's not clear how much less regulated it will be than charitable companies limited by guarantee under the Companies Act 2006. There may be little incentive to change to a CIO for existing companies. CIO, the pluses. So it provides a single incorporated structure for charities. There'll only be one regulator, the Charity Commission. If you were a charitable CLG, there would be two regulators, Companies House and Charities Commission. People respect a charity, and also it's a simpler constitutional form, but will it be easier than a charitable company? Okay, we've got to the end of the slides. There's probably quite a few more questions than answers, but I hope that these slides have got you thinking about everything and encouraged you to investigate one of your more favourite options. We can teach you more about these things and we can help you go through them and help you through using a governance questionnaire to decide which business model suits you best. There are some useful sites to look at. Obviously ours, the Wales Co-op Centre, have lots of resources and information for you to look at and some guides that you can download. The government website, plenty of information on there. You can navigate your way around the site and look at the various models and their articles. And we also have the Social Business Wales website. Again, lots of useful resources and guidance. I hope that you found this presentation useful. This is me. You can contact me on these numbers and the email address. And I can also then signpost you to the most suitable officer in your area and we can get talking. Thank you very much.